rise today as a Treaty First Nations woman from the Michelle First Nation and as a member of the Legislative Assembly to speak firmly and clearly in opposition to Bill 1. This bill is not a harmless administrative measure. It is not simply about jurisdiction clarification. Bill 1, in its current form, is a gross infringement on treaty rights, a violation on Indigenous jurisdiction, and an egregious transgression on the constitutional foundations of this province and of this country. And because this bill was not created without First Nations leadership, it was not created in consultation with Treaty 6, 7, and 8 chiefs, the ignorance of this government is to not recognize that our treaties was made with the Crown, and they are international agreements, is of absolute failure of this government. This bill cannot pass without an amendment that clearly and explicitly outlines the intention of upholding and protecting Aboriginal and treaty rights. Let me remind this UCP government that treaties are the supreme law of this land. Furthermore, Section 52 of the Constitution states, "The Constitution of Canada is the supreme law of Canada. Therefore, treaty is the supreme law of this land." Now, whether the UCP government wants to admit it or abide by it, the rule of law is simply the rule of law within this country. And Section 35 recognizes and affirms existing and Aboriginal treaty rights. This government apparently needs a history lesson and needs to be reminded that our treaties predate Confederation. They are not policy agreements. They are not program expectations. They are the foundational covenants that made the settlements of these lands possible. The covenants that we hold as sacred, the covenants that we visit year after year, smoking the pipe, singing the songs, reminding ourselves of our responsibility and obligations that we made in this agreement. These settlements were made without war, without violence, and in the spirit of coexisting in peace, in friendship, as to live as relatives on this land. This legally binding contract has absolutely no exit clause. It is to last as long as the sun shines, the grass grows, and the rivers flow. Canada's legal traditions recognize this in our multi-juridical state of common law, civil law, and Indigenous law. All three are obligated to uphold this international agreement. Furthermore, our neighbour to the south, the United States Constitution, affirms that treaties made under the authority of the state shall be the supreme law of the land. The United States, well known for its colonial history, affirms Indigenous treaties as binding and supreme. How is it that in Alberta in 2025, we are debating whether our government, this government, is respecting our treaty rights? The United Nations Declaration on the Rights of Indigenous Peoples recognizes treaties are matters of international concern. The United Nations Declaration on the Rights of Indigenous People, Article 19, states clearly that states shall consult and cooperate in good faith. And I would argue that this government did not operate in good faith in the creation of this bill. They did not seek consultation. They did not have prior and informed consent from the treaty rights holders of this land. So the quote is, Article 19, states shall consult and cooperate in good faith in order to obtain free, prior and informed consent before adopting measures that may affect Indigenous peoples. Of course, international agreements impact Indigenous peoples. Our very foundation to these lands are international agreements. The UCP did not operate or cooperate in good faith. They did not obtain free and prior informed consents with treaty rights holders in the construction of Bill 1. And let it be known that also Indigenous peoples in the province have the right to recognition, observance, and enforcement of our treaties. Which means Alberta, Canada have to honor and respect our treaties. Article 37 states this clearly. For a government that uses a lot of beads and feathers and proclamations of First Nations partnerships, guaranteed loans just like a money mart, but I digress. Let me be clear. A government that proclaims to do the work of reconciliation cannot at the same time pass laws that knowingly circumvent the rights of Indigenous peoples. Reconciliation is not only about apologies or ceremonies. Reconciliation lives or dies right here on the floor of this legislature. As it stands, this bill does not explicitly include a non-abrogation clause on treaty. It infringes on treaties' rights because treaties are international agreements. There was a time when members of Treaty 6 traveled back to the United Kingdom to discuss in the British Parliament this very issue of affirming these international treaties. And the Honour of the Crown, back in 1982, Lord Denning, speaking on treaty promises, said in the House, "No Parliament shall do anything to lessen the worth of these guarantees. They should be honoured as long as the sun rises and the rivers flow. The promise must never be broken." Yet today, we are being asked to consider legislation that does exactly that. It weakens those guarantees by omission. To pretend that treaty rights are unaffected in this bill is either a complete misunderstanding or a deliberate evasion. Let me remind this UCP government that the Library of Parliament states clearly, both provincial and federal governments share responsibility for upholding treaties, and this obligation arises from Section 35 and the Honour of the Crown. This government does not get to unilaterally decide when treaty rights apply. They do not get to claim jurisdiction without assuming responsibility, and you cannot benefit from treaty lands while denying treaty obligations. I want to emphasize that Bill 1 is not about prosperity. It is about separatism. Albertans are strong Canadians. They are proud of the province's role in federation. They do not want to be isolated. They do not want to be pushed towards separatism, and First Nations will uphold their treaty rights. Treaties 1 through 11 are all part of Turtle Island, part of Canada. This bill contributes to a divisive narrative, a narrative that this government has fueled repeatedly, suggesting Alberta can or should opt out of federal or international agreements. This simply is not possible. As a Treaty First Nations person, I'm here to remind you that this cannot happen, and you are wasting time and taxpayers' money to even imagine doing so. This legislation is not built on prosperity. It does not create jobs. It does not lower costs. It does not support families. It is political theatre designed to distract, to inflame, and manufacture conflict with Ottawa. And, sadly, it creates racist rhetoric for First Nations against separatists, fueling an idea that will legally never be possible. All of Alberta is on treaty land. This nonsense bill being brought forward while families struggle with health care crisis, families struggle with food in the fridge, communities desperately in search for safety, and the UCP government chooses a symbolic fight instead of doing the real work. Let me remind this House, you are not treaty makers, you are the treaty beneficiaries. These lands, the land, the ones beneath our homes, the roads, our schools, and this very legislature are treaty lands. Bill 1 asks Albertans to believe that this province can exercise sovereignty without acknowledging the very agreements that allow Alberta to exist at all. And so I ask you openly and directly, how will this government and its citizens and settlers and visitors, how are they going to survive on a landless province? You know, Mr. Speaker, when Quebec attempted to separate, they didn't succeed. A province cannot be recognized as a nation by the United Nations, is what they said. The international community said, no, you are not a nation. And this foolish debate about separatism is wasting our time. Alberta will meet the same wall that Quebec did and will have an even weaker argument than Quebec. Because treaty is not only our right to uphold, treaty is all of our protection. Hey, hey.